here. We're not trying to force them out. We're just trying to let them know that. All right. So this case number is 26-14184-FH. Appearances, please.
Joanna Garrett for the people.
Thank you. All may be seated. Mr. Keeler is here next to counsel. All right, I see Mr. Keeler is from Hibma Road. That's the one road that seems to cross and you pop up against it all over the place. Although it stops for a mile, continues for another mile, stops. Anyways, all right, so I'm giving it all enough time to talk about, tell them what's going on, but I'm told here that we intend to, the parties intend to enter a plea. Miss Gary, why don't you go ahead and tell me what it is?
My understanding, the defendant's going to plead guilty to added count 2 operating while intoxicated. Second offense, the people will dismiss the third offense notice. And it's my understanding that at least I do not have a substance use assessment. Have a plea sheet if the court would like that.
Yeah, plea sheet and then advice of rights would be great, gentlemen. Counsel, you may. And I don't know if you did this actually intentionally, sir, but you are wearing Hope College colors, so that's a point in your favor. Okay. Thank you very much, but not a big one. All right, Mr. Shuey, is that correct and accurate statement?
That is my understanding, Your Honor, and that is true. We have not had an assessment yet. I wasn't quite certain.
No,
I was going to ask for a pre-sentence investigation.
I will. All right, Mr. Keeler, have you heard what the attorneys have told me we're going to do today?
Yes.
Is that how you wish to resolve the case?
Yes.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Mr. Keeler, looking back on December 19th of 2025, were you on probation or parole?
No, Your Honor.
Were you on bond pending any felony charges at that time?
No, Your Honor.
All right, thank you. You are currently charged on a piece of paper called a felony information with a single count. That count is operating the vehicle while intoxicated or impaired as a third offense. Now, initially, an operating while intoxicated is a misdemeanor punishable by up to 93 days and or a minimum of 100 up to a maximum of $500 and or 360 hours of community service plus other costs for rehabilitation, prosecution, and mandatory vehicle mobilization. However, because it's charged as a third, that increases that from being a misdemeanor to a felony and the maximum punishment up to a minimum of $500 to a maximum of $5,000 in fines plus costs. And then either a choice of, which is given by the court, a minimum of 1 year to a maximum of 5 years in prison, or the alternative to a prison sentence, a period of probation and a mandatory minimum of 30 days to a maximum of 1 year in jail. Plus, again, costs for prosecution, costs for emergency responses, costs for rehabilitative programming, vehicle mobilization of at least 1 year and up to 3 years. However, I'm told that count 1 will be dismissed if you enter a plea of guilty to, and I accept that plea, and added count 2. Added count 2 would be a lesser version, it'd be the one right in between what I've talked about. I gave you what the maximum punishments were for just a simple drinking and driving. And then I told you what they were for what you're charged, which is the drinking and driving third. You're going to plead to a drinking and driving second. That is a misdemeanor punishable by up to 1 year and or up to $1,000. Plus there would be cost for rehabilitative programming, cost for prosecution, cost for any emergency responses by law enforcement, and also vehicle immobilization would be mandatory. You understand?
Yes, Your Honor.
All right. Now, this, by the way, is what I see contained here on this written pretrial agreement, and it appears to have your signature. I'm holding it up. Is that your signature?
Yes, Your Honor.
Now, did you talk about all this with the counsel?
Yes, Your Honor.
Was he able to answer all your questions?
Yes, Your Honor.
And are you satisfied with his advice and representation?
Yes, Your Honor.
And do you believe so far taking this plea is in your best interest?
Yes, Your Honor.
Thank you. Now, if you enter a plea of guilty, and I accept that plea, you'll be waiving certain rights, not have a trial. Does that make sense?
Yes, Your Honor.
Now, I'm holding up a form that your counsel also gave to me, and at the top it says advice of rights, at the bottom has your signature. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty and I accept that plea as we discussed, you will be forever waiving these rights as they apply to this particular case?
Yes, Your Honor.
Also, you'll be given up the right to claim that the plea will result in any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, inducements?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, Mr. Sui's probably talked to you about potential sentencing. Now that it would be a misdemeanor, not a felony, the sentencing guidelines don't apply. And he's probably tried to give you an idea or an estimate as to what he thinks the court may sentence you to. Has he or anyone promised you exactly what the sentence would be from this court?
No, Your Honor.
Knowing all that, do you still wish to enter the plea of guilty as we discussed earlier on the record?
Yes, Your Honor.
As to the added count 2 of operating while intoxicated as a second offense, how do you plead, sir?
Guilty.
Before the court can accept that plea, I need you to tell me what it is that happened on or about December 19th here in the city of Cadillac in Westford County. Were you operating a vehicle?
Yes, Your Honor.
And it looks like it was in a highway or a roadway open to the public. Is that correct?
Correct, Your Honor.
And it looks like it is over on Paulister, which is on the south end of Cadillac, just before you go up the big cemetery hill, right?
Yes, Your Honor.
And were you pulled over by a police officer?
Yes, Your Honor.
And prior to that, had you been consuming alcohol?
Yes, Your Honor.
And again, you were operating the vehicle?
Yes, Your Honor.
Ms. Carey, does the prosecution have a blood alcohol?
There was a
Number?
blood draw. The result was 0.183.
Mr. Sui, does the defense stipulate for the acceptance of the plea and the sentence?
I do, Your Honor.
All right. Ms. Carey, do you believe the defense provided a factual basis in addition to the acceptance of that blood alcohol test?
I do.
Oh, hold on. I'll cover the second element in a second. Are you aware of any other promises, threats, or inducements?
Not,
Maybe the court's compliance with scroll 6.302.
yes.
Mr. Sui, how about you? Do you agree with all that?
I do, Your Honor.
So, Mr. Keeler, what I forgot to ask you is one other question, and that is about the second the second offense. So I will pick the last one that I see listed here, and is it true that on or about August 5th of 2004 in the 56th A District Court down in Eaton County, you were convicted of operating while intoxicated?
Yes, Your Honor.
All right. The court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements for the added count 2. Therefore, the defendant is found guilty of operating while intoxicated as the second offense. The higher offense, the felony, will be dismissed at the time of sentencing. So what we do here is, even though it's a misdemeanor, I still have a pre-sentence investigation report prepared. One of these reports must be prepared when someone's convicted of a felony in a state court of Michigan, but I also will have them prepared when I'm considering a period of probation, which may be appropriate. Therefore, when you leave this courtroom, you're going to go downstairs to the bottom floor, which is also called the ground floor. You take the elevator or the steps, they end up at the same place. All the way down to that ground floor, do a button hook to the right. At the end of that hallway, there'll be a door. Go through the door. If you know where community corrections is at,
Yes, Your Honor.
if you were to stand right in front of their office, do an about face and take 3 steps forward, you'd be right where you need to be. They're going to give you a packet. You're going to complete that packet, turn it in. They will schedule an interview with you. You have the right to have your counsel present during that interview. They will also issue this report generally about 10 days, maybe 2 weeks prior to our sentencing date. We do sentencings in this court every Monday morning. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide, as well as information about any prior criminal history you have, performance on bond, performance on probation, and or I didn't see a fourth habitual enhancement, so there's no parole issues. We'll also make a recommendation of sentence. Please keep in mind it's merely a recommendation. If you're getting any kind of treatment or seeking that out on your own, or if I gave you any or the courts gave you any enhanced outpatient treatment programming through corrections, I encourage you either to pursue it or keep pursuing it. Either way, those things will go a long way with me. Mr. Sui, any questions, anything further?
Your Honor, I do have one bond request
Okay,
made on behalf of Mr. Keeler, if it's appropriate now.
yeah, Ms. Carey, any objection to the time concerns?
No,
Go ahead, sir.
Your Honor, Mr. Keeler has full custody of his 17-year-old daughter, and we had planned a trip on March 27th to April 5th to Savannah, Georgia, before this actually even happened. Obviously, he understands he cannot leave without permission from this court.
Ms.
He has-
Carey, any objection to allowing a bond modification to permit him to travel out of the state?
no,
All right, okay,
I was just gonna say that he's been doing AA, he's been doing everything that bond has been asked to do, and he's been tested negative.
I would add that it's still tests there. I've been to Savannah, so.
did you go to the Garden of Good and Evil? It's a book.
I have, Your Honor.
All right. And Johnny Mercer's from there? Are we still playing it? Yeah. But anyways, I'm sorry, I digress. All right, the court will modify the bond to allow the defendant to leave on those, between those dates, leave the state of Michigan to travel to and from Savannah, Georgia. His bond condition of he still can't possess or use alcohol and will be subject to random testing. That can be difficult, but so when you're going down there, think ahead. Find out where the local sheriff's department is, and maybe make a phone call and say, hey, if this happens, can I come in and get a test? And they'll normally say yes, and it might cost you $10, $20, but that's about it, okay?
Yes.
If you have any questions, think ahead. Ask the people down in the community corrections office. Their job isn't to make your life difficult, it's to help make sure that sobriety is what you're doing, okay? So I hope you enjoy the visit. It's a very beautiful town. A lot of history there, so. Anything else, Mr. Sweet?
Nothing further, Your Honor.
Can I get the dates again?
Yeah, would you please state those dates again?
It would be March 27th through April 5th.
If anything happens with travel, thunderstorm or tornadoes or whatever, just reach out to community corrections and say, listen, this is where I'm at. Okay, make sure it's fine. And always ask for permission and let people know, and then the court will not have any problem with it. Okay. All right, good. Enjoy your trip. We are adjourned. Thank you. All right, we're going to take back up the case of People versus Larry Mitchell. File number again is 25-1.